Now, go ahead.
I don't see, to broaden out Justice Kagan's question, I don't see your formulation of intent in our copyright cases either, in Calum, in Grokster, in Sony, or in the patent law context in Henry either. That seems to suggest a more affirmative advertisement, promotion, instruction kind of formulation to get to purpose. So can you deal with the copyright case law more generally?
I'd be delighted to. And the copyright law, if you go all the way back to the Harper case in 1886, has this notion of material contribution. And material contribution is an absolute critical aspect of copyright secondary liabilities as it's developed over the years. And I think it's important to understand that, yeah, you're right. Grokster, as I tried to explain, didn't focus on material contribution, but that's because the knowledge of specific infringing works was missing there essentially by design of the product. Now, Sony, I think, actually does talk a fair amount about material contribution. And what it talks about is, it says a couple of things. In the text around footnote 18, it makes clear that one of the things that made that body of case law inapplicable, and it talks about the dance hall cases and a whole bunch of common law cases, those aren't applicable there because there's no ongoing relationship. And it's sort of, and so in that context where it's a one and done sale, then you really are forced to rely on the patent context of a staple article of commerce that you just launch in and you have no way of ascertaining any knowledge. I think, though, it's very telling that in footnote 19, Justice Stevens refers to the trademark law. Now, he says the trademark law is not as apposite there as the patent law, but that's because trademark law is actually narrower in most respects. But he specifically cites this court's decision in Inwood Labs. And Inwood Labs could not be clearer that the standard is inducement or material contribution as defined exactly as I'm defining it, which is to provide the means of infringement to a customer you know is going to use it to infringe. And I'll give you substantially certain on top of that.
Mr.